I want to welcome everybody to today's webinar. I'm Harry Nelson. I'm proud to be co-presenting today with my colleague, Natalie Birnbaum. And our topic today is the implications of California's new reproductive healthcare laws for providers. Understanding these laws, the impacts that they have on provider practices, and guiding questions for risk analysis. The laws that we're going to be talking about today are hot off the presses. September 27th, they were signed into law. And we deliberately tried to focus this presentation a little bit more succinctly so that we have time for questions. Really, the goal is to make this presentation as practically useful as possible for providers. So I wanted just to give a couple of disclaimers before we get started. First, the webinar is intended for educational purposes only, and it's not being offered and shouldn't be relied upon as legal advice or to the extent that we say anything clinical, medical advice. Opinions expressed are our opinions as presenters, not any organizations. And we encourage everybody listening on their own behalf, on behalf of the organizations that they're part of, to take this information and consult with clinicians on certainly anything clinical that we discuss, and attorneys on anything legal to address particular situations. So I want to turn it over to my colleague, Natalie, to kick us off.
Thanks, Harry, for that intro. So we'll just start by doing a bit of a broad overview on shield laws. And, again, we're going to try and keep this we're not going to get too deep on the nuances here, because we do want to make this as practical as possible for providers. So shield laws, I'm sure you've heard of them by now. Since last May, when Connecticut led the charge really in introducing this type of law, we've seen these laws pop up in abortion expanded and abortion access states throughout the country. So these laws seek to protect a range of stakeholders in states where abortion is protected from the reach of states with civil, criminal, and licensure consequences that stem from the provision or the receipt of abortion care. So each of these laws has their own nuance and their own scope. So it's important not to think, oh, okay, my state has a shield law, it must be like Massachusetts, it must be like California's, it must be like Vermont's, because that's simply not the case. And it's really critical that everyone has a thorough understanding of what exactly their state's shield law protects. And another way of framing what these laws do, really they enable legally protected healthcare in their state to continue occurring. They allow providers and abortion funds and abortion seekers to continue receiving healthcare. And just caveat that it's not necessarily that they allow that from happening, but they provide as much protection as possible so that those practices may safely continue. So there are limitations and then there are protections. Again, the scope really depends on what your specific law says, but typically they cover providers, helpers, and patients' medical records. These laws do not protect directly the patient or the abortion seeker, unless, like in California, and we'll get to that soon, that state has a safe haven law, which would protect that abortion seeker or person who had an abortion if they are physically located in the state of California from out-of-state law enforcement officials. So other protections that are typical in shield laws include medical malpractice protections, limiting adverse professional licensing consequences from a state medical board or nursing board, clawback lawsuits, and against criminal investigation. And some states, the majority of states, also prevent extradition from happening. Limitations are your shield law only protects you while you're in the state that's shielded. So that even means that if you're in New York, New York's law technically would not protect a California provider. However, because of the laws in New York and in Massachusetts and in other states that have similar shield laws, it seems unlikely that New York would not protect a California provider. And there are ways that attorney generals are working together to ensure that they are recognizing other states' shield laws. So stay tuned for something on that term. Other limitations include practicing medicine in a state without a license. If you are practicing in a state utilizing a shield law, you may not be licensed in that state, and the state may have licensure repercussions or even criminal or civil penalties for practicing medicine without a license. And the laws ultimately remain untested, which I think is like the thing you've probably heard over and over and over again, but it remains true. So it's really critical that you get an individual risk analysis and truly understand the protections for your practice and in your state.
And Natalie, before we jump into the states, the maps, I just wanted to add, just for context for everyone who's listening, to understand sort of the significance of shield laws. I think it's important just to say that historically, the practice of medicine was regulated by each of the 50 states separately at the state level, right? And essentially, states were seen to be regulating the delivery of care in their states. And by the way, when we talk about the origin, the beginning of telehealth, which we'll talk about, which is important to talk to today's conversation, when that began, the idea was that the care was taking place originally where the patient was. We called that in telemedicine the originating site, and the site where the provider was the distant site, meaning that the site where the patient was located was the site that determined which state licensing laws applied. So what's really significant here is that shield laws are really sort of challenging that, and in order to provide access to healthcare, are really staking a claim that providers licensed in one state can provide in another state. And I want to point out that that is really a challenge to the historic paradigm that we'll come back to as we later in our presentation.
Thanks, Harry. So this is our first map. It's a national map of interstate shield protections. As you can see, the green states are shield law states with out-of-state telemedicine abortion protections, meaning these states' protections specifically extend to, just the scenario that Harry was discussing when a patient is located in a different state from the provider. So providing telemedicine abortion to a patient out of state. And right now there are 21 states in total with some sort of shield law. And again, only these 6 states highlighted extend specifically to out-of-state telehealth care. Another interesting point about the 21 states, which is also represented on this slide, is that some of those states are shield laws, and a few of them are just by executive order. So it's also important to understand if your state has a shield law by executive order, that may just last the term of your governor. And it's important, if you are a provider, to ensure you have the highest protections possible and that they are longstanding. So the second map is a national map of interstate shield protections for gender affirming care. And many of the states that also offer protections for abortion or more broadly reproductive health care services also are including shields for gender affirming care.
So we wanted to, before we get back into the shield laws directly and the practice of medicine, we wanted to talk about 2 California laws related to this topic that are really focused on privacy and data security. So the first is Assembly Bill 254, which was signed into law, which expands the applicability of California's state health privacy law, which is called the California Confidentiality of Medical Information Act, or CMIA. And essentially, that law was amended by AB 254 to define medical information to include, reproductive or sexual health application information, and specifically defining that to include consumers' reproductive health, menstrual cycle, fertility, pregnancy outcome, plans to conceive, type of sexual activity collected from a mobile app or website. Now, historically, the CMIA was a law that really focused on healthcare providers and did not focus on consumer applications. But what's very clear here is that the government, California state government, is expanding the reach of this health privacy law to cover consumer apps. This would include period trackers and others, all kinds of programs that are keeping keeping this data. So it's a very significant expansion of California's state privacy law. And CMIA has been, predates HIPAA. It has in other ways, it's also more restrictive than HIPAA. For example, when it relates to marketing, it was updated a couple years ago to cover genomic information that was being stored. But this is a very significant revision of California law to protect data that's out there through consumer applications, not only through healthcare provider apps and websites. So a new significant restriction that's taking effect as of this coming January 1. And the second law that was passed, Assembly Bill 352, is actually something that applies directly to healthcare providers with respect to their electronic health records. And this requires providers to adopt additional restrictions on information that's related to both gender-affirming care and abortion-related services, as well as contraception, right? And that means to segregate this information from other records, so it's not just contained in an entire medical record. This is very significant, for example, when there's a subpoena about records, by the way, and that could be in theory in a case against a provider, but it could also be in other contexts. For example, these records are often sought in family court proceedings, for example, where child custody or other issues are at stake. This information must be segregated from the rest of the health record. It's prevented by this law from being sent out of state, where other states might take a different position. And essentially, providers are prohibited from sharing this information with anyone in another state, with very, very limited exceptions. And so this is a significant protection that really differentiates both gender-affirming care-related information, abortion and abortion-related services, and contraception information, and really is something significant that providers will need to be taking account of when it takes effect this coming January. But really a signal by the state of California that there's going to be not just legal protection that we're going to talk about with the SHIELD laws, but a real sort of blocking and protecting of data that could be used in a different state to try to restrict or sanction someone for these kinds of care.
Yeah, and just building off of that, this law attempts to get at the scenario where, you have a patient EHR, and in that whole, in the EHR, it obviously says, okay, you have abortion care. So what if the Texas provider is subpoenaed and shows the information that's in their EHR from the California provider, and the California provider doesn't even need to do anything. So the goal really is to prevent that information from even getting into another state, so that that Texas provider would have no reason or no law preventing them from sharing that information. And I'm just going to highlight one of the comments in the chat right now, is that unfortunately the vendors don't have ways for us to segregate that data yet. And I'm curious, Harry, if you know of any ways that you see any changes of that happening in the industry.
Yeah, I think it's a great point. Obviously the electronic health record vendors are going to be slow to offer resources to do this. And I think my advice to providers would be that this may be a situation where we actually have to go back to paper records when it comes to some of this care, as crazy as that sounds, or at least to segregate it outside of the EHR, the same EHR system. So it may be necessary in the short term to actually go back in sort of a technological sense, just to keep this information out of the record. But I do think that that's a problem that is going to be hitting all of the major healthcare organizations, and I'm sure we're going to be seeing all of the EHR vendors addressing it. The question is, of course, going to be how will they get there much in advance of January, or even in some cases after that. So definitely a practical challenge posed by this law.
Yeah, and also, there are some patients that will want this information in their EHR to continue care. And I think that's also important to acknowledge, because Harry, when you did mention there are limited exceptions and circumstances where you can share this information, one of those is when the patient consents to sharing that information.
Absolutely, yeah. So right, so patients can opt out of this, and it's an interesting question. Who is at who's at risk? And there's definitely going to need to be more unpacking of this rule and its implications.
Yeah, another question just came in that I want to highlight, which is, do you know of any EMR companies that are not complying with the law and any lawsuits against them? And I would say, initially this is obviously too new, this law to have that. And, EMRs aren't even required to comply with this until July 1st, 2024. But Harry, perhaps you're familiar in other areas of the law where you've seen
in behavioral, the biggest thing we've seen, like for example, in behavioral health, there's been attention to certain kinds of substance abuse records needing other care. Let me back up a second. The classic example of a record that always needs to be screened out, also as a behavioral mental health example, is psychotherapy notes, right? So there's a higher degree of protection in the law in that case, because there are cases where psychotherapy notes and where people confided secrets could actually be harmful to another person, to that person. For example, if someone is describing a pattern of abuse that they've been subjected to, and then the abuser or the abuser's lawyer is able to get those records, we want to prevent that. In some cases, it could be harmful to the individual themselves to know what their psychotherapist's analysis is, and so we put real limits in that. And there are examples of software, that actually flags it and makes it easier to segregate those records out, so that it doesn't require exhaustive effort when there's a request to produce. We have similar examples in the drug addiction space with regard to certain records, but I would say there's only a handful of vendors that I'm aware of that actually have built in those kind of solutions. And I think there's going to need to be pressure from reproductive health providers to get EHR vendors moving on this issue. Obviously, California is only one of 50 states, and this law is, you have vendors all over the country who are going to have to decide what to do, with their software. So I think we're going to need some affirmative progress. I don't think there's a solution on the market right now that addresses this that I'm aware of.
Yeah, exactly. And I think the more pressure and the more states that adopt similar policies, the more likely it is that the vendors will respond. So then this brings us to SB 345, which is California's SHIELD law, although these other laws also, of course, have SHIELD law protections. So SB 345 really builds upon Governor Newsom's previous executive order protecting healthcare providers and abortion helpers and a whole range of stakeholders in the provision of abortion care. So the law prohibits California law enforcement, government officials, or government contractors from cooperating with out-of-state prosecutions related to abortion, contraception, or gender-affirming care. And I think it's important to note that this is much more expansive than Governor Newsom's original executive order, which just included abortion care. And on the licensure side, it prevents a California Healing Arts Board from prohibiting them from taking disciplinary action or denying an application based on the provision of legally protected care, and that includes nursing boards and medical board, who both, by the way, supported this bill, and also extends the definition of reproductive healthcare services and gender affirming care services very broadly, and includes reproductive health, ranging from surgical care, dispensing, and even just supportive care, and of course, telehealth. Also significantly, when it comes to data privacy, is that this law prohibits California-based corporations, including social media and tech companies, from disclosing to law enforcement any private communication of patients regarding healthcare that is legally protected in California. So who does this law apply to? Licensed providers authorized to offer abortion care in California, any individual supporting, performing, or aiding in the performance or receipt of sexual reproductive health care and gender affirming care, including abortion funds, which of course is significant, as we've all seen, the lawsuit coming out of Texas and the discovery request there. And on that note, I would also say practically, When you are contracting with third parties, make sure you have very clear contracts, and you're having a lawyer hopefully review them to prevent the flow of information and to protect your privacy. Because again, can't emphasize enough that these laws are untested, and the way they will actually play out and come into practice is an ongoing process. But there are pre-existing parts of the law that can help support us as we implement these new protections, which we'll get to momentarily. So the final group of people that SB 345 applies to are individuals receiving sexual and reproductive health care and gender affirming care in California. And again, that is that safe haven aspect of the bill. Now, I think it's important to also think about the scenarios that this bill would apply to. So we have a healthcare provider that's licensed in California providing telemedicine abortion to a patient located in another state, and that provider is licensed there. That is one scenario. Another scenario is that provider is licensed and located in California, and they're providing care to a patient that is in a hostile state. So long as that care is legally protected in California, then this SHIELD law purports to protect that provider. There's also a third scenario that this law protects from or seeks to protect from, which is when that California licensed provider is in a third state and that care that they're providing in that third state is legal. So like, let's say they go to New York and provide care, or they're in another expanded state that does not have necessarily SHIELD law, but there is abortion access in that state. When that provider physically goes back to California, California's SHIELD law will then apply to that provider. So there are a few other laws that are also worth mentioning that were passed 2 weeks ago. AB 571, which ensures California providers have access to professional liability insurance without facing discrimination because of abortion or gender affirming care services. And in the law itself, it is written that, one of the bases of discrimination is providing care into a state where that care is not legally protected. So again, that should cover, hypothetically, SHIELD law states if the provider is providing into that state. But we also need to see that there are enforcement mechanisms put in place for insurance providers to make sure they are not actually upcharging or denying licensure, professional liability insurance. So SB 487 adds safeguards for abortion providers who participate in the Medi-Cal program. AB 1720 requires ultrasounds to be conducted in licensed facilities. AB 1646 and SB 385 are aimed at increasing the reproductive healthcare workforce. And then AB 576, which has not yet passed, updates Medi-Cal to reimburse providers for the provision of telemab, which of course, practically speaking, is incredibly important. And I think I read today that NARAL is doing a phone banking for that bill later today.
So we wanted to give you some tools to sort of think about how to take advantage of these laws if you're a provider that's considering doing so. This chart describes sort of the analysis of how to think about rendering telemedicine abortion services. So the first question is, where is your patient located? As I mentioned earlier, traditionally, California providers could only treat patients who were located in California. There were obviously questions that would arise when patients would travel, or, for example, people who were snowbirds or people who were away at college. But in general, the question was, is a patient a California resident or are they present in California? And on the left side of the chart, we have the traditional analysis that would have taken place, right? The question is, are you as a healthcare provider, are you licensed in California and operating within the scope of your license? Are you doing so in compliance with telehealth laws in terms of standard of care, which we'll talk about on some of the coming slides? Are you in compliance with data privacy laws? And in the case of telemedicine abortion, because until very recently, the dispensation actually had to happen through the physician office, are you dispensing directly? And now, of course, there is the pharmacy option, and we'll talk about both physician and provider dispensing and use of a pharmacy. So that's the traditional analysis on the left side of the page. On the right side of the page is really the questions that are opened up by SB 345, the Shield Law. If a patient is in another state that no longer forecloses the possibility of rendering services, providers should still ask the question: is this a state where abortion is permitted or not? Is this a state where abortion is banned? On the right side, are you licensed in that state? And we are going to talk on one of the coming slides about the issues of what the implications are if you have a license in the other state. Are you licensed in California, right? The SB 345 is intended to protect licensed California providers. Is telemedicine abortion permitted in that state? And can a telehealth license exception apply? So there is a path on the sort of right side of the slide under the abortion permitted column where SB 345 could extend access in states where abortion is already permitted, but California providers are additionally now available. And on the right side of the page is really where we expect most of the potential conflict and controversy to come, which is the ability of California providers to go into states effectively via telemedicine where abortion is banned by that state, and to rely upon their California license, the fact even being located in California, and provide care. And obviously that requires a risk assessment of the risk to the patient and the risk to you.
Yeah. And I'll just add, of course, this is not legal advice, as we have to disclaim over and over again, and you should consult your individual attorney. However, it is much less risky, and actually, in terms of travel and other risks that we'll get to momentarily, to provide abortion care in a state that abortion is permitted and that you are licensed. I would not recommend going into a state utilizing the Shield Law where abortion is permitted and you don't have a license and practicing there. It just feels like an unnecessary risk to take because there are licensure laws that we all are following. Additionally, another area that could be interesting to look at when you're doing your risk analysis is, many states in the practice of telehealth have exceptions where providers can come into their state and don't have a license or issued a temporary license due to an emergency situation or the continuity of care. Now, this is just another area for you to explore with your attorney or independently, and then bring it to an attorney and say, hey, I want to provide into the state, whether it is an abortion access state or a hostile state. Perhaps there is a shortcut or an exception to a typical licensure pathway.
So we wanted to just sort of go through some of the central risks that providers should be thinking about when it comes to providing telemedicine. So one of the first issues is verification requirements. A number of states, and we covered this actually on previous webinars, have enacted verification requirements with respect to telemedicine in general, regarding, and some by the way with regard to telemedicine abortion in particular, but about whether the jurisdiction requires external proof of who the patient is or authentication of the patient location. These laws are specific state to state, and so this is part of the kind of risk calculus for providers in providing telehealth. By the way, it's very interesting. Before telemedicine really expanded and grew, there was never a requirement that doctors checked patient IDs. It was only in the era of telemedicine that state medical boards started raising the question of whether patients might, not state clearly or correctly who they were, and whether in some way, that this became an additional obligation that providers had to take on. As that,
to clarify your point, I just want to add, a verification requirement does not mean that you need to collect identification in the forms of a driver's license or formal identification from your patient. Some states have verification requirements and some states don't. And it is commonly accepted that to verify a patient's location, that many of the telemap sites are just asking, double asking where that patient is located, perhaps even looking, where that browser is coming in from. But ID is not necessarily, although again, you want to check your state law, the way that's necessitated to verify identity. And it's important to name because, when we think of telehealth equity issues and people that may not necessarily have an ID or feel comfortable sharing an ID, that we don't enforce that as the standard.
Yeah, 100%. This is an issue that requires a different level of sensitivity in telemedicine abortion. It's very interesting. I'm really referencing the broader kind of evolution of telemedicine. By the way, and a lot of this, just to kind of give some context, is driven by a concern about patient sort of misrepresentation in a broader sense of who the patient is. But also in the COVID era, we saw a growing concern and a lot of pressure from payers to verify exactly who was where and what was going on in the telemedicine encounter. And so kind of a sort of contrary trend, if you will, in healthcare that's pushing up against issues coming up here.
Yeah, and just listing a comment from the chat, does California require verification? The answer to that, I believe, is no.
California does, California does not explicitly have any law or regulation that requires verification. We have seen in medical board cases, the board was for some time really questioning the lack of obtaining verification, but we have seen in general a little bit of a softening on that. So it's sort of been one of those underground issues in California and no formal requirement.
Yeah. However, from a practical standpoint, as a provider offering care into another state, it is important for your risk assessment and for your liability to be as clear as possible that your patient is not that your patient is a real patient seeking abortion care, and B is not located in a state where you are not either licensed or you're not comfortable providing care in, or you're choosing not to provide care in. So, there again, it may not be an ID, and maybe California doesn't have on the book exactly the procedure of how to do it, but it is important to take steps to ensure that your patient's identity is verified for your own liability purposes.
So just to run through some of these quickly, obviously this is all about licensing. Is a provider licensed to render services, right? Pre SB 345 in the jurisdiction, under SB 345 certainly in California. And I included, whenever you're talking about non-physician practitioners like nurse practitioners and physician assistants, then you have to also add here to the question: is there appropriate supervision? Are people practicing within their scope of practice? Number 3, telemedicine regulations. So this really, every state has taken slightly different approaches to what the appropriate modalities of care are, right? Telemedicine can be conducted in a real-time synchronous live video, right? Patient and the provider in the encounter, seeing each other and speaking to each other in real time. Asynchronously, where the encounter is entirely sort of messaging and exchanging data back and forth at different times. And then a middle kind of category of what we call interactive audio, where there's messaging back and forth, but there's some phone call or other audio kind of verification. And we'll come to how providers should think about that. That's a state-specific issue. California permits all 3 types of modalities. And also, of course, whether the condition being treated and the medication is appropriate to telemedicine. Some states have enacted specific laws about particular medications. In California, the only one you have to really watch out for as a category is controlled substances, which we're not talking about today, and whether there's a limitation in that jurisdiction. Number 4, kind of the broader category of practice of medicine laws, right? Is standard of care being satisfied? There's a fundamental principle in telemedicine that standard of care doesn't change, that the provider needs to be able to meet the standard of care, and we'll talk more about that, whether the encounter takes place virtually and remotely or in person. Appropriate history of inquiring about all the right things, appropriate examination. That's really the most important aspect of meeting practice of medicine requirements in every state, and of course, medical record keeping requirements. And finally, are there any particular terms that need to be disclosed to a patient, consents that need to be obtained? And that's sort of when providers are thinking about what they need to do, this is hopefully a helpful sort of way to break down the different aspects that come into a telemedicine encounter. So we wanted to get into the dispensing issues that come up. And here, we just to give people, if people are not familiar, California has a very specific law that protects the right of providers, physicians, prescribers to dispense medications, right? So that law, Business and Professions Code, Section 4170, has been around for a while, and it comes up quite frequently. And it essentially it says that no prescriber shall dispense drugs to patients except in their own office or place of practice. So to their own patient in their place of practice. This law, by the way, is often thought of as intending to protect pharmacies, and really the fact that pharmacies are intended in our system to be the primary site of dispensation. This is kind of an exception to allow prescribers to prescribe. But so to your own patient in the office or place of practice, there's have to be labels that are equivalent to what pharmacies would be required to put on or provide with the medication. You have to disclose to the patient that they have the right to have a written prescription to fill at a pharmacy, a disclosure about that they always have that choice. There are a few other technical requirements, like not having a dispensing machine. Prescribers, physicians actually cannot own more than 10% of a pharmacy, and are not supposed to keep a pharmacy if they're dispensing in this way. And finally, the requirement to store drugs securely. So those requirements that I just went through, Business and Professions Code Section 4170, really govern the case of any provider who's going to be dispensing medication. It's definitely important to be familiar with those. And of course, you have the option, as a result of changes in federal law this past year, to instead dispense through pharmacies, which we'll talk about in just a minute. But these laws are, by the way, very different state to state. There are a handful of states that actually don't allow for physician dispensation. This is the California specific version. And of course, the issue comes up in applying the SHIELD law. What can California providers do in terms of sending pills to patients? So the law, as I described, says no prescriber shall dispense except to their own patient in their place of practice. That suggests the law doesn't explicitly say that drugs can't be mailed, but it certainly implies it. It's very interesting because this law often sort of falls between the cracks of it's not really enforced by the California Board of Pharmacy, because they don't police, they police pharmacies, not physicians. And it's sort of also the state medical board. So it's one of those rules that has been on the books forever. It's not actively enforced to our observation, but it is a challenge to this issue of sending pills to the patient that the providers will have to navigate. And so anyway, we just put that out there for your consideration. Obviously, you have to take account, as indicated on the right side of the slide, by whether you're licensed to prescribe in that state, or licensed to dispense, and those could be issues that come up that we'll talk about with regard to the risks in the next couple slides.
Yeah, thanks, Harry. And again, just to emphasize your point, each state has their own ways and procedures and laws around dispensing. So we're just talking about California's for the purpose of this conversation, but this chart can be used regardless of what state you're in order to do an analysis. And here, just in California, recently, GenBioPro, there was an article in Politico that GenBioPro released the names of the different pharmacies in California that actually are dispensing MAB. So we just included this slide in case it is helpful for your practice. And on the website, they also include pharmacies throughout the country, but again, staying California-centric, that's what we are highlighting.
So we wanted to just spend a little bit of time talking about standard of care in terms of what is needed to justify a prescription, and with regard to telemedicine. This is also a topic we've talked about a little bit on some of our past webinars, but just to recap, for telemedicine abortion, a clinician, first of all, let me back up a second. The fundamental question of standard of care is what a reasonable physician or reasonable provider would do under the same circumstances, in terms of what they need to, what information they need to have from the patient in terms of history, what questions they need to ask, what kind of examination they need to conduct. And essentially for telemedicine, a clinician needs to know that the patient requesting care is pregnant, that they want an abortion, and that they are eligible for treatment. On some of our past webinars, we had Dr. Beth Raymond, who really went through the research to undergird how additional requirements that have been imposed over time have really been, inconsistent with what is really legal, required for patient safety. And so that's sort of the big topic, but these are really the core questions that need to be asked, right? We're always talking about telemedicine needing to meet the same standard as in-person care, even though it's being provided in a different format. And the question is really, what data points does a provider need to evaluate a patient? What exam needs to be done in person, if any, right? And when we have asynchronous care, the very nature of asynchronous care suggests there's nothing being done in person, that it's safe, that we can obtain enough data, the provider can obtain enough data asynchronously just by messaging to decide that a particular method of care and a prescription, for example, is appropriate. The question is, can patients accurately report and self-screen? The entire undergirding of telemedicine in this area where we're dealing with such a sensitive subject, I think inherently requires that we believe patients when they indicate that they are pregnant and want an abortion. I think providers are really are sort of that's almost kind of integral to what we're talking about here. We can talk a little bit on in the next couple slides about the value of interaction, given that the providers are essentially relying on the patient. In my opinion, it makes it that much better to have some live conversation, whether it happens on an interactive audio phone basis or otherwise, just so that the provider has some assurance that the patient is legitimate, that they're not dealing with someone who's like a just sort of testing systems, for example, like a mystery shopper who has malicious intent in contacting the provider. But that's sort of the core question. The question of whether any labs or tests are needed, which we addressed on previous webinars as not being necessary here, and whether the medicine can be self-administered. So, and we always make reference to this, in terms of medical record keeping. What's taught in most clinical training programs is the idea of a SOAP note: subjective, objective, assessment, plan. Right? The provider describes what the patient is saying. Objective records the key data points that objectively need to be recorded. Notes the differential diagnosis, and which is even though we're talking about a very focused condition, there still is a differential diagnosis that this patient is appropriate for this medication, and the treatment plan, which is really the prescription and instructions for use. And the important point here is telehealth never alters the scope of practice or the standard of care in that sense.
Harry, I'm lifting a question from the comments about advanced provision. How do these requirements or data points interact with the ability to provide pills in advance?
It's a great question, right? So in general, sort of most classically, providers waited until the patient had a specific problem, or coming with a complaint, essentially, of some kind about how they were feeling, and then the provider treated. However, we have lots of examples where where as long as the provider thought that was confident that the patient understood how to use the medication, understood when it was appropriate, and was sort of competent to safeguard and use the medication appropriately at the right time. We have other examples where medications are given in advance. The classic one being travel medications, right, where people might be going to a country that has malaria, and they're given a malaria medication. So that's just one. I could give you many other examples, but I will say that our belief is that the advanced provision is appropriate and warranted as long as the provider is satisfied that the patient understands how to use the medication, understands the safety dimensions, and that in that way, advanced prescribing of mifepristone and misoprostol is no different than all the other kinds of advanced provision of medications that are that we make in our system.
Yeah. And before you do that, you should consult an attorney because again, it does come with a lot of risk. And again, checking in what state, what your comfortability with risk is and doing a deeper dive is important. But I think it's a really great perspective. And Harry, when you were speaking, I was thinking, oh yeah, okay, going into another country where you may need malaria pills. Well, now we're in a healthcare situation in our state where you can be going to college and you're not able to access the abortion pill in your state. But of course, that opens up the whole other side of what is the patient risk, which is incredibly important for your patient to analyze and for you as a provider to be aware of.
Okay, so I wanted to just say a little bit about standard of care. And I say this with some trepidation because I'm not a clinician. We're not clinicians. I'm not a clinician. And really, standard of care is a question for clinicians. One of the hardest questions that frequently comes up is the issue of the REMS certification. REMS is the 2008 FDA program, Risk Evaluation and Mitigation Studies, where the FDA established certain medications having additional, very specific requirements, and anyone who's who's prescribing mifepristone is aware that should be aware that there are these very rigorous requirements that frankly seem in many ways at odds with the general purpose of the REMS program, which is mostly focused on medications that are that are really causing risk. For example, like opioid medications, that where providers needed more education. And so the question comes up, the REMS program that comes up is the REMS program was intended to limit off-label prescribing. Off-label prescribing is the idea that in our system that prescribers have the right, once a medication is approved by the FDA for any indication, to prescribe it where the provider believes it would be appropriate. And off-label prescribing is inherent. Certainly, misoprostol is inherently it's a medication that is by definition being used off-label. The question comes up of off-label prescribing of mifepristone. As an empirical matter, we know that many providers are doing this. And on this, I only listed here to say that from time to time, when state medical boards have investigated or brought enforcement actions, they will make reference to FDA standards as part of the standard of care. So, meaning, in other words, even though standard of care is supposed to be what a reasonable provider would do, and it should mean that you could look around and say, well, geez, every other provider is doing it this way and is using this medication off-label. There's a risk that medical boards could potentially go back and say, hey, wait a second, the FDA has all these requirements. So I'm not opining in here about whether they're part of standard of care. I only am really flagging this as a potential risk issue that needs attention. And candidly, this should be a reason for states like California that are intending to be protective to actually affirmatively, push on against the kind of restrictive nature of the REMS in this case. Obviously, it would be nice to see the FDA revise its information because, as we discussed on previous webinars, some of the information is just totally inconsistent with clinical research. But that's an issue that we just want to highlight. The core part of standard of care analysis, as I mentioned on the last slide, are these questions about what exchange needs to happen with the patient, what history, what exam, and what sort of just documenting a discussion with the patient, calculating the duration of the pregnancy, discussing, particularly given, as we discussed on one of our past webinars, that the clinical research demonstrates that ectopic pregnancy risks can be ruled out in a number of ways, sort of discussing that with patients, ensuring that there's no sort of unusual history that would be contraindicative of the medications. And then the third aspect of standard of care is just ensuring that the treatment plan, meaning the prescription, the instructions, the dispensation, so that patients know what to do, what follow-up they should have, when to contact the provider, or seek additional care, is clear. And that's sort of the core elements of standard of care. Okay, so we wanted to turn to really one of the big questions is, what are the risks, the practical legal risks that providers should be thinking about in using taking advantage of SB 345. And if you are a provider who's going to do that, we have to say that while California has taken this step, we are uncertain as of this time how anti-abortion, hostile state medical boards, how law enforcement or other kind of statutorily empowered activists in those states are going to respond to SB 345 or to other shield laws. And this raises a question of whether providers are at risk if they happen to live in a hostile state, or if they are traveling to a hostile state, or if they hold a license in a hostile state. And we know, for example, that some providers are choosing not to have licenses in states that might take action, because having a license in a state means that that state has the right to potentially pursue investigation or enforcement action against the license. And this is sort of just an open topic that really creates some uncertainty. And in addition, we do expect that that hostile state actors will likely present challenges in federal court to SB 345 and other shield laws. These laws raise really interesting questions about our federal system and about the idea that each state is sovereign, right? That this is the 10th Amendment, the idea that the powers not held by the federal government are reserved to each state. And there is certainly risk that these issues will be before the courts in the near future. And part of what we wanted to just highlight here is that a lot of good sort of protective self-protection is taken in advance of anything going wrong, right? One of the classic issues that often comes up is we will get questions from providers about how to protect themselves personally, how to protect their risk regarding their license, but also how to protect themselves financially. And one of the critical lessons is that you have to. These are all issues you have to take advantage of in advance before the problems surface, right? And just for example, on the pure issue of financial planning, whenever a party is already a problem's manifested and lawsuits begun and investigation has begun, it's almost too late to start taking action at that point, right? That there's a risk, for example, if you're in a lawsuit and you decide to start moving money away so that you have no assets that could satisfy a judgment, there's a risk that you'll be pursued for what's called fraudulent conveyance, right? So we wanted to highlight for providers some basic risk reduction, risk mitigation strategies. And the way that I think about these, having been asked by physicians to address this, many, many times over the years, is really in kind of different levels of asset protection. And this is sort of kind of in advancing levels of seriousness. Some of the issue that always comes up, we always get asked in all kinds of healthcare ventures and what do we do to reduce our risk? And so the sort of basic level of thinking about risk in everything that you do as a provider should encompass thinking about insurance. Like, are you covered by insurance? Is there insurance coverage for if this risk manifests? Indemnification, meaning who's responsible to cover the cost of this, and who's going to defend this if there's a legal action? And is there anything I can put into the contractual terms or disclaimers that are going to limit the risk, right? Beyond that, when it comes to personal sort of planning with regard to businesses, sort of sound planning as a second level of risk management, where we're thinking about using entities, right? And not only forming corporations or limited liability companies, but actually being careful to respect what's called respect the corporate formalities, meaning using them appropriately, keeping funds separated, ensuring what actions are being done personally versus actions being done in the name of a corporation, right? Avoiding personal guarantees and making lawful transfers of assets in advance of problems. Those are all sort of good examples of a second level of asset protection. There are certain kinds of basic asset protection that that every person, who has every professional and anyone who has assets to protect should be thinking about. These are basic kind of estate planning terms that that all estate planning lawyers work with. Things like revocable living trusts that make it harder for creditors to reach assets, and essentially thinking about where things are protected. For example, retirement accounts are entitled to a certain level of protection federally under ERISA. In some states, your house is actually a place where you have protected equity, even if in a bankruptcy, right, by virtue of homestead laws. So taking advantage of those laws is another level of asset protection. We've been asked, what are the higher levels of asset protection? And for people who have significant resources and are worried about the possibility of risk coming up, advanced asset protection, there are a lot of structures that estate planning lawyers work with more high net worth individuals to really limit access to assets, some of which are sort of basic structures that are used widely in the United States, like charitable remainder trusts and various qualified personal residence and terminal interest Q-tip trusts, spendthrift trusts. And then there's this very, very high level of asset protection that we do see from time to time of people using offshore trusts in places like the Cook Islands and captive insurance and sort of stripping out equity. These are all sort of radical approaches that are probably only applicable to a narrow band of people. But asset protection is a sort of distinct subject that is worth being educated about and thinking about to figure out what's appropriate. And it's not merely an issue for people who have resources that they're worried about that may be implicated by the services they're rendering. It raises sort of fundamental equity issues. Natalie, I know you wanted to make a comment about that.
Yeah, just to really understand how asset protection applies here and understanding it in context of the SHIELD laws, it is so critical to remember that the SHIELD laws in California and in other places cannot prevent a lawsuit from happening out of state. What they do offer, and at least what California offers and other states offer, is a clawback provision, meaning you can go and have a countersuit. However, the money that your assets are still at risk. In the same way, on the criminal level, the SHIELD laws cannot prevent the warrant from occurring. So while there are protections while you're in state, it does not prevent actions being taken that may impact your assets, your finances, or your criminal liability in another state.
So this is it's kind of an extreme topic, but we received a number of questions and hope that this is helpful to people to start thinking about how to mitigate risk.
So thank you all. We have a few outstanding questions in the chat that we were not able to get to. So if you want to reach out afterwards, feel free. And thank you all for attending. We hope this is helpful, and we will send out a copy of the program and the slides as well.